Caregiver's Corner webinar series. My name is Jane Kogan, and I'm HDSA's Education Advocacy Manager. Today, we're going to hear about planning for incapacity from Sean William Scott. Before I invite Sean to begin, I'm going to go over how to ask a question and how to access this webinar after broadcast. Sean will be answering questions after the conclusion of his formal presentation, but you can send a question at any time by typing it in to the question pane on the right-hand side of your screen. After typing in your question, you hit send. And just as a reminder, these questions will all be answered after the conclusion of the formal presentation. This webinar will be available approximately 1 week after broadcast on the HDSA website. To access the presentation, go to www.hdsa.org/ccorner. You'll be able to view a webinar recording as well as download a copy of the presentation. And for this presentation, I'm actually very, very excited because Sean has also agreed to make his book available as one of the resources. So thank you so much for that. You can also find HDSA's Lunch and Learn webinars at hdsa.org/ll. And both of these are also available if you just go through the Living with HD section of the HDSA website. As far as future webinars, next month on November 19th, we're going to hear about family planning for HD. And you should receive an email about that, and that can also be found at www.hdsa.org/ccorner. We also have a webinar for professionals coming up on Social Security disabilities, and you can contact me at www.hdsa.org to register for that webinar. And now I'm really excited to introduce Sean Scott. Sean has been practicing elder law in the state of Florida for 20 years, concentrating on the legal issues that affect aging communities throughout the state. His areas of legal concentration are Medicaid benefits, incapacity, and estate planning and administration. Sean is an adjunct professor for St. Petersburg College, the author of the Medicaid Handbook, and host of the Age with Confidence podcast. And now I'm really excited to turn it over to Sean.
All right. Well, good afternoon, everybody. We're going to set this up to make sure that it works out okay. I'm glad to be here. Thank you for having me. I hope we're going to have some interesting things to show you and to speak with you regarding the issue of incapacity planning. Incapacity planning is oftentimes given such a short shrift when dealing with your future plans. We sometimes overlook it, but in no other context other than in the context of Huntington's disease or any other progressive disease process is incapacity planning more important. It is something that should be on the front burner of your world, and it's something that's so easy to take care of and so easy to fix that everyone should have one regardless of whether you are in a situation where you have a disease process that's bringing you towards incapacity or whether or not you are just trucking along in life, kind of a normal situation. So with today's presentation, we've captioned it Co-Pilots and Roadmaps. Co-Pilots and Roadmaps is a good metaphor for the issue of incapacity planning. During incapacity, you lose the ability to manage your own affairs. You can't make the decisions that we normally take for granted on a day-to-day basis. Things like what type of care I'm going to choose, what kind of financial decisions I'm going to make, the mundane things of writing a check to pay a bill. These sort of things that we take for granted on a day-to-day basis become huge challenges if you lose the cognitive ability and or physical ability to interact and to make those decisions on your behalf. So again, back to this issue of co-pilots and roadmaps. When we talk about the issue of incapacity, we're oftentimes looking at determining who is going to be in a situation to make decisions on our behalf if we can't do that. That's the functional equivalent of a co-pilot in an airplane. The roadmap situation is one where we need to be told, or we would like to tell the people around us where we would like to go, what we would like to have happen, and how we'd like to get there. So before we jump into that co-pilot and roadmap situation in greater depth, I wanted to go over some of our goals for today. The first is I want everybody to understand the importance of incapacity planning and why it's so important. The second thing is I'd like to distinguish two main areas of incapacity planning to focus upon. Next, I want to describe the different methods to solve these incapacity issues and what you need to do and the action you need to take in order to put a plan in place in order to fix this particular problem. Next, the benefits to an HD patient and his family when you put an incapacity plan in place. What is the benefit? What do you get out of taking this action in order to solve this problem? And lastly, specifically, I do want to reinforce the issues of what steps you specifically need to take in order to get an incapacity plan in place. Very easy, very straightforward, and as I like to say, it's not really rocket science. It just takes a little bit of your time and a little bit of action on your part to fix this very important problem. So, when we talk about incapacity planning, I use the metaphor of a co-pilot. There's a reason why they put 2 seats in the front of every airplane. If you've ever been on an airline flight and you look up into the cockpit, you'll see a seat for the left side, that's for the pilot, and there's always a seat on the right side. That seat on the right side is for the co-pilot. Why do you have a co-pilot? I think the answer is pretty straightforward, just in case something happens to the pilot. Within the last month, we've actually had an interesting real-world example of this on an airline flight to Dallas. The pilot had a massive heart attack en route and died, literally died, in the left seat of the airplane. But that plane didn't crash. It didn't destroy the lives of 150 people sitting behind him. It was fairly much a non-issue for those people in the back of the airplane because there was a co-pilot sitting next to him. That co-pilot took the controls of the airplane, used his training and his skills, and landed that airplane successfully without anybody actually being the worse for wear of that particular situation. In your life, and everyone's life, we are the pilot of our own life, metaphorically speaking. We control the direction of our life. We control what happens to us on a day-to-day basis. We control and make the decisions that affect our journey. However, if something happens to us, whether it be something sudden like a stroke or something more of a progressive degenerative process such as HD or Alzheimer's, we have a situation where we may not be able to be the pilot of our airplane any longer. In that particular circumstance, we need to look towards a co-pilot. But that seat to our right is actually not filled until you take some affirmative action to appoint that co-pilot. You appoint that co-pilot by signing some legal documents. 2 legal documents we're going to discuss in a moment are the durable power of attorney and the healthcare surrogate. Both of these are effectively a pilot's license for your co-pilot to act on your behalf. It's very important what that pilot's license says. It has to say the correct things as far as what their skill set is, what they're allowed to do, what their powers are, what their capacity is, and to what the scope of that capacity is. It literally tells them what they can and cannot do. So that document becomes very important. Without that license, without that granting of authority, you don't have a co-pilot sitting next to you. And if something does happen where you're not able to fly your plane, the plane will crash with devastating results. So very, very important that we have a co-pilot in place. Additionally, to a co-pilot, I use the metaphor of a roadmap. So not only do we need to tell the world who is going to step in and fill our shoes in the event of an incapacitating event, but we also should tell that person, that co-pilot, where we want them to go. Where in the world, where is the direction that we want them to take? This is especially important when it comes down to healthcare decisions. What kind of healthcare decisions do you want that person to make on your behalf if you cannot speak to the healthcare professionals on your own? This does get down to some very personal and very serious issues of end-of-life decisions. Do you want those kinds of treatments that would extend your life? I hate to say unnecessarily, but in some circumstances, the measure of quality and quantity sometimes comes into our philosophical discussion as to what you want to have happen. Should something happen where you are in a position where death is going to occur or is likely to occur, what do you want to have happen? If you cannot speak on your own and on your own behalf, you need to have somebody that can speak with a map in their hand that tells them where you'd like to go. So that's the concept of a roadmap. Nothing more complicated than really expressing what your desires are and what direction you'd like to go. So to reinforce this, the co-pilot is really the person that takes the controls when you can't fly the plane any longer, the person that's going to step in and fill your shoes. The roadmap is really telling the world where you want to go, what you want, and what you want to happen. Very simply, very clearly expressed in that idea of the healthcare surrogate. The power of attorney does have some of that direction, so to speak, but less so than the healthcare surrogate. Power of attorney is more focused on giving the person these specific legal powers that they'll need in order to manage your financial affairs. So let's talk a little bit about this whole concept of durable power of attorney. Durable power of attorney has its roots back in Old England, actually, where somebody could appoint an agent to be their representative. That if they could not appear in front of the court to ask for something, they could appoint somebody to be their agent to go and plead their case and ask for the thing that they wanted, or to transact other business on their behalf if they couldn't physically be present. This was appointing somebody, again, to be you. Over the course of time, this concept has evolved to what we have in present day, which is something known as a durable power of attorney. And what this piece of paper does is it appoints your agent, your person to fill your shoes, and back to our metaphor, your co-pilot. That document sometimes can be very simple on its face and is oftentimes, in my opinion, taken for granted. There are a lot of forms that are available out there on the internet, for example, that you can use and download. You can go to your local office supply store and get a form there. You can go to your local library, perhaps, and get a book discussing how to use a power of attorney to plan for your incapacity. I strongly caution people against doing this, however. These are what I call DIY powers of attorney, or do-it-yourself powers of attorney. What often happens is you get a document, you get a pilot's license, to continue our metaphor, that is not sufficient in really granting the authority that is necessary for that person to be able to act upon your behalf. Here in Florida, we routinely run into problems with powers of attorney that are not drafted correctly. They simply are lacking particular powers that are necessary for that person to act on your behalf. I'm going to go over some example of some of those powers in just a second. Simply stated, powers of attorney are usually dealing with your financial affairs. They are granting authority in your agent to act on your behalf for financial purposes normally. They also give that person the ability to act on your behalf for say, litigation purposes. They can sue and take legal action on your behalf. But the main force of the durable power of attorney is so that your agent, your co-pilot, can manage your financial affairs. I often get asked the question, what is the difference between a durable power of attorney versus a regular power of attorney? And unfortunately, in my world, I sometimes will use the terms interchangeably. I will say you need a power of attorney, that a power of attorney does this, and I'll drop the word durable. But technically speaking, in order for a power of attorney to act on your behalf after you've lost capacity, it needs to be durable. There are two different flavors or types of powers of attorney in the world. One is a power of attorney, and the other one is a durable power of attorney. Almost all documents that you'll run into today are going to be of the durable nature, but technically there is a difference. And that it's an interesting difference, actually, because a regular plain vanilla power of attorney only has the ability to act on your behalf if you still have legal capacity. If you don't have legal capacity any longer, the capacity that your agent has also diminishes and is also then non-existent. So a regular power of attorney doesn't do us much good for planning for incapacity, and we really need to make sure that our document is a durable power of attorney. In order to determine whether or not your document is a durable power of attorney, it's simply a matter of reviewing the language and looking for a specific sentence, basically, that says this, that this document, this grant of authority, shall survive my subsequent incapacity. That language makes the document durable. Durable in the sense that it has duration beyond your individual incapacity and inability to manage your affairs. It solves that problem of a regular power of attorney losing authority when you lose your capacity. All that being said, Please forgive me if I will sometimes fall back and just call it a regular, or just call it a power of attorney in our discussion today. I want you to understand, though, there is very much a distinction between the two documents, between what a durable power of attorney and a regular power of attorney is. As you'll see later on, even in my slides, I'll use the acronym POA to mean power of attorney instead of using the acronym DPOA, which would be durable power of attorney. Just remember, whenever I use the word power of attorney in this presentation, I'm specifically referencing a durable power of attorney. The other way that we can plan for incapacity, and the other side of the incapacity planning coin, is something known as a healthcare surrogate designation, or living will, or a combination of those two things. This is also sometimes referred to in other jurisdictions as a power of attorney for healthcare or healthcare power of attorney. Same concept that we had with the financial durable power of attorney, in that you are appointing a person to act in your stead to take care of your healthcare affairs versus your financial affairs. So when we're talking about healthcare surrogates, we're talking about the medical side of things as opposed to the financial side of things in your world. Let's drill down a little bit and talk about some of the various different variations on this particular type of document that you'll use to plan for this particular problem. There are three things that you're likely to run into, three different types of documents that solve this problem. I've mentioned them just briefly before, but let's take a look at them a little closer. There's the healthcare surrogate designation, there's the living will, and then there's the durable power of attorney for healthcare. In my world, what I've done in my practice is I've kind of consolidated all of these three concepts into one document that I refer to as a healthcare surrogate designation. But in some jurisdictions and some lawyers, that may be actually a different document, or at least not quite as encompassing as the one that I use in my particular practice. A lot of times what a healthcare surrogate is just simply a designation of somebody to make healthcare decisions for you. Many times it's just one page. It says that Jane Smith, for example, will step into my shoes and be my healthcare surrogate and speak to my doctors and make healthcare decisions on my behalf if I'm not able to do that. Oftentimes when you have that simple kind of healthcare surrogate designation, there'll be an accompanying living will that comes along with it. That living will is a document that expresses what your end-of-life decisions are. And it basically says that if any of these prerequisites occur, I'm in an end-of-life situation, I have a terminal illness, I'm in a coma or a vegetative state, any of these particular triggering events occur, then I want you, the medical professional, not to do heroic life-saving measures and to merely let the natural process of dying occur. However, you may want to have a living will that says the opposite. It's your prerogative to tell us what you want to have happen, to give us what your particular roadmap would be. I do documents, living wills, for example, that are just the opposite. Some clients want absolutely everything possibly done medically to keep them alive, as long as it is medically possible to keep them alive, regardless of whether or not there's any medical probability of the recovery from that particular problem. There is no wrong decision as to what you want to have happen. The trend for most of my clients is to pick the document or the choice which says not to artificially prolong my life. But many people will, on the other side, choose the opposite and say that I want you to do everything you possibly can do. A very personal decision that you have to make for yourself. Suffice it to say, however, that this living will document is the expression, is the map that tells us what you want to have happen and should not be treated lightly. In my world, I take the healthcare surrogate designation and the living will and combine them into one document. I go into great detail as to the types of things that I want to have happen in the event that I can't talk to my doctor, and I specifically appoint a person to step into my shoes if I cannot fill them to make those kinds of decisions. So at this point I want to make a distinction between a power of attorney, a durable power of attorney, and a healthcare surrogate. In Florida, for example, it may be different in other states, but we used to have a type of power of attorney document that would only become effective to allow the co-pilot to fly on your behalf in the event that you lost capacity, in that event that you can no longer fly your own airplane. These were called springing powers of attorney. They would spring into life in the event that you lost the ability. This was to manage your affairs. These were done basically to try to keep that power in your control and not give or duplicate that power into somebody else. Florida recently, last year, got rid of that particular type of power of attorney, and that is no longer a valid document in this particular jurisdiction. So for those of you who are listening outside the state of Florida, it's important that you localize a lot of what I'm saying today to your particular jurisdiction. You may have the ability to do that, for example, to have that kind of document in your particular state, not available in Florida. In Florida, when you create a durable power of attorney, that authority to act on your behalf, the ability to fly the airplane, is immediately replicated in your co-pilot. They have that ability immediately upon signing your document. What I like to stress, however, is that you are not giving up that control. You are not you're not able to do that yourself any longer, and only they can act on your behalf. It's more of a type of a concept where you're duplicating or replicating yourself, and they have the ability to act as well as you do. Now, naturally, for some people, that can be a very scary thing. They don't want to have this person running around, being them, being able to fly the airplane in any direction that they want to fly it. And there's some reluctance to give that authority to the co-pilot. I can understand that, and that's a valid concern, I think. However, it pales in comparison, though, to not having a power of attorney in the first place. So in order to kind of placate and sort of reduce that fear that this person will go off and act on their, without your consent, so to speak, we have a very practical solution that we employ in our office. And that is, instead of giving this pilot license to the co-pilot, instead of giving them the power of attorney currently, immediately, right now, I have you hold that document in your files, kind of keeping that back, but by telling your son or your daughter or whoever your co-pilot is where that document is, that they can access it if they need to. So that's kind of a practical solution to that particular problem. The healthcare surrogate, on the other hand, the distinction between power of attorney and healthcare surrogate is that usually the healthcare surrogate is only effective in the event that you cannot provide informed consent. And what that means is that you don't have the requisite legal capacity to intelligently and capably speak with your physician to determine what type of health care, what type of procedures, and what the course of that treatment is going to be. Only upon that event, when you cannot provide informed consent any longer, does your healthcare surrogate co-pilot, so to speak, step up and be able to speak on your behalf. So let me repeat that just so you see that distinction. Powers of attorney are typically effective immediately upon the signing of the document, and that person has basically all the authority that you have to act upon your life. That person also has that authority to act upon your financial life. The healthcare surrogate, only effective, usually only effective when you lose the ability to provide informed consent. So there is a trigger when you lose capacity for that healthcare surrogate to become effective. It's not effective prior to that time period. All right, there's one document that I did not speak about, and that's because it's not something that's typically, that I typically think of as a legal document. It's called a DNRO, which stands for a Do Not Resuscitate Order. The order part comes from that it is literally a medical order, a physician's order that says do not resuscitate that particular individual. This is a document that's oftentimes implemented in consultation with your physician. In many jurisdictions, it requires a specific form to be filled out, one that has been approved by that particular state. In Florida, we have a do not resuscitate order that comes on a yellow piece of paper with a big red stop sign on it, and it is only that document that will suffice as a do not resuscitate order. There is oftentimes a lot of confusion between a healthcare surrogate and a do not resuscitate order, a lot of confusion between a living will and a do not resuscitate order. Simply stated, a living will is not a do not resuscitate order. It may say do not resuscitate me, but it does not have the same force and effect that a DNRO does. This is, I guess, The best example of this, and the easiest way to show the distinction between this, is a little story that I tell about an EMT coming to your house, a paramedic coming to your house. A paramedic has been called for whatever reason. Maybe there's been a heart attack or some sort of emergency. That paramedic comes storming through the door, and they're going to then revive you. But your spouse or your son is standing over your body, and they have a living will that says, do not resuscitate in it. It says, don't do anything to this person. The EMT is going to ignore that living will. Even though it says, don't resuscitate me, it's not a do not resuscitate order. They will go and they will still perform that life-saving measures in order to bring you back. They will take you to the hospital. The physician will evaluate you at that point in time, and it is only after that kind of emergency circumstances have been resolved that we'll look towards the living will as to what to do next. Do not resuscitate order is much different. A do not resuscitate order in the state of Florida, as the story goes, that when those EMTs show up, if you stand over the body with that yellow form in your hand, the red stop sign, then they will not perform the life-saving measures. To give you another story, one of my clients once, and this is a great story because it really shows the difference between a living will and a do not resuscitate order. She was a caregiver for an individual that had a progressive degenerative disease. He was aging. He was living in an assisted living facility, and one day he was experiencing some problems breathing and some issues with his cognitive abilities. He was acting very, very strangely. So the assisted living facility called the EMTs. They also called her. The EMTs showed up, collected him, took him to the hospital, and she finally, within probably about 45 minutes, though, not really that long, shows up at the hospital as well. When she gets there, she goes, where's Mr. Smith? Where's Mr. Smith? And they take her down to Mr. Smith's room in the emergency room. Mr. Smith is just sitting there in the bed with nothing happening. And my client, or his representative at that point, gets a little upset and says, well, why in the world why aren't you doing anything? Why isn't he hooked up to any machines? Why isn't he getting any oxygen at this point in time? She was very upset, which I can understand. However, as it turns out, and as she knows, and it took her a second and took her a couple of minutes actually to realize what the situation was, Mr. Smith had a do not resuscitate order in his chart at that hospital. So when he came rolling into the emergency room, they looked at his chart. They said, do not resuscitate. So they were not going to do anything for him in that particular situation. If he was having a stroke, if he was in a cardiac arrest, they were not going to do anything to stop that progression of his normal process of dying because of the do not resuscitate order that was in effect. So later on, we were talking about this a couple of days later. We were discussing that. And I asked her the question. I was like, well, what did you expect? And when you go to take the next step of putting a do not resuscitate order in place, this is the reality of what's going to happen in those circumstances. And since he was not in a position to change that orally with the physician or with the doctor, to say, yes, ignore that do not resuscitate order. I want you to do everything possible that you can do. That do not resuscitate order was going to speak on his behalf. So, very important distinction here, especially when people are dealing with terminal illnesses and progressive degenerative illnesses that are likely to lead to a very unpleasant end for them. A do not resuscitate order may be an important thing to consider in your overall incapacity planning toolkit to make sure that, and unfortunately I'll say it somewhat jokingly, that if you're lucky enough to draw, let's say, the heart attack card, that may be a better result than going through the process of the degenerative disease and dying of that particular disease process. Again, very personal, something you all have to look at in your own world and make your own decisions onto that. I only provide you this insight for sake of discussion and for sake of expanding your perception on this particular issue. All right, that is a do not resuscitate order, often referred to as a DNRO. It is not a document that you will draft with your lawyer, but one that you need to speak with your physician regarding. As a footnote to that, when we talk about a healthcare surrogate designation, that healthcare surrogate that you've named can, in the event of you losing capacity, enter into that discussion with the doctor to get that do not resuscitate order in place. Okay, I hope everybody understands that. All right, the whole purpose of this incapacity planning, other than providing this co-pilot and the roadmap, is to avoid a process known as guardianship. If you don't have a power of attorney and a healthcare surrogate in place, and you are not able to manage your affairs, whether those affairs be financial or medical, and there's nobody to turn to get answers regarding the questions that we have, then we will have to go through a court process called a guardianship. Now, a guardianship is generally, it's a good idea generally to avoid this process. It's not absolute like everything, but the general idea with the power of attorney and healthcare surrogate is to avoid having to go to court and go through the process of presenting a case and proving a case that the individual does not have legal capacity. That's a lengthy process. It involves bringing the person into court, having them evaluated by a panel of experts in many cases, at least in the state of Florida, and then having a court case and a hearing regarding that individual's capacity. This takes time, this takes money, this takes a lot of effort. There's an attorney involved for the person filing the petition to determine capacity. There's also an attorney appointed for the person who's alleged incapacitated, the person that does not have the power of attorney or healthcare surrogate, and can take up to 3 months to finally get some sort of determination regarding that individual's capacity and the appointment of a guardian to act on their behalf. In some cases, when we don't have a go-to person, when we don't have a very good selection, a son or a daughter that we can trust, a spouse that's in the situation that can act as our power of attorney and healthcare surrogate, then maybe we don't have a good person to step into your shoes to be your co-pilot, and we'll rely on the court appointing that person for you. The only way we can get that person appointed, if we don't have a power of attorney and a healthcare surrogate, is to go through a process called guardianship. Okay, when do you plan? When do you put an incapacity plan in place? I like to say, what part of now isn't a good time? Putting off to some other future date to get these pieces of paper in place, to make sure that you have an incapacity plan in place, serves no purpose to wait to some point in time in the future. Even if you have a disease process that is dragging you towards that incapacity event at some point in time in your life, we're not going to wait, or we shouldn't wait until we get closer to that point in time to put these papers in place. Even if you're a healthy individual, even if, as I like to say, my 19-year-old daughter has a durable power and a healthcare surrogate in place today. She has no degenerative disease process, she has no diagnosis, she has no history of any types of illnesses, and yet every day she drives in a car and she is susceptible to some sort of event that could put her in a place where she does not have the ability to manage her affairs. My two best examples of that are some sort of debilitating accident like a car accident, or something along the lines of a stroke, which we weren't thinking about, weren't anticipate that would happen, but our brain fails us, that blood vessel lets go, and all of a sudden we go from being able to manage our affairs to not being able to manage our affairs in a matter of minutes. We need to have these incapacity plans in place now, not some point in time in the future. When is it too late? Let's say you are a procrastinator and you don't take action to put some sort of plan into place today. When is it too late to get a plan in place? This is not really what I would call a black and white answer. With incapacity, especially if we're dealing with a debilitating disease process, the individual may go through various stages through that process where they are not wholly incapacitated, but not fully in a position where they can manage their own affairs. It can get very delicate, so to speak, as to determine when that person has truly lost capacity. In my practice, it's incumbent upon me to make that decision. To give you some insight into this, even if a physician has said that person does not have the ability to manage their affairs, oftentimes written in their chart, they don't have the ability to make their health care decisions, they don't have the ability to manage their affairs, we can still, from a legal perspective, get a durable power of attorney and a health care surrogate in place. Again, from a legal perspective, the only time that you cannot put a power of attorney and a healthcare surrogate in place is if there's been a petition to determine capacity filed. In other words, if a guardianship has been started. Up to that point, it's still possible to get a power of attorney in place. I got to stress possible, though, because there does come a time in my practice and my dealings with clients where that person, where I cannot legally, ethically, and morally allow them to sign a power of attorney or a healthcare surrogate designation because, as I like to say, their capacity train has gone around the bend. The capacity is very much like a train. There's a lot of cars involved in it. There's a lot of different variations in capacity. At some point in time, however, that person just does not have the ability to sign these documents any longer. The trick is here to do it before the last car has gone around the bend. In my practice, I do unfortunately have to deal with people who have procrastinated, who have not taken any action to put a power of attorney in place. It's very easy to not take action. It's very easy to say that you'll do that some other day. You don't want to approach this particular issue with your family member, whether it's your father or mother or a sibling or your spouse, because it's too uncomfortable to discuss for whatever reason. So you ignore it and you don't address the topic of incapacity planning. You never put the power of attorney and healthcare surrogate in place until the issue is really staring you right in the face and you just can't ignore it any longer. Hopefully, by that point in time, it has not become too late. It has not become a situation where that person's capacity has gone completely and they cannot execute the document. All of this, I'd like to stress another point, is that I do look for something known as a period of lucidity. Many of my clients which are suffering from some sort of debilitative disease process, and I oftentimes we'll look at Alzheimer's as a good example here as well, just for discussion, is that that particular disease may present periods of time when that person knows who they are, when they know where they are, where they know who they would like to act on their behalf. And if I can get out of them in or during that period of lucidity, expressing that desire to me, then I can get the power of attorney executed and we can move forward with implementing the plan. Obviously, it's a lot better time to do it before I have to look for that period of lucidity, before we have to keep our fingers crossed and hope that they still have the ability to sign this document. I want to talk about signing for just a second. The inability to sign the document does not mean that you cannot get the document in place. The physical ability to sign a power of attorney does not inability does not limit your ability to get this document. Simply stated, let's say a person has no use of their hands. They can't hold a pen whatsoever. Just because they can't sign their name to the document doesn't mean they can't have a durable power of attorney. If they can express to me that they want a specific individual to serve in their capacity, to act in the place, act as their agent under the power of attorney, to be their co-pilot, then I can sign the document on their behalf. They can also scratch an X or put a little bit of line or anything on that document that they intend to be their signature. But if they can't do that, I can sign the document on their behalf and attest to the fact that they were physically unable to sign the power of attorney and healthcare surrogate. That will create a valid document. 5 things that need to be in every durable power of attorney. In my jurisdiction, in the state of Florida, many of the documents that I review, even the documents that are done by other lawyers, are insufficient to adequately convey the powers and authority that's necessary. In other words, they create a co-pilot, but they don't create a very good co-pilot. They forget, for example, how to teach the co-pilot how to land the airplane, a pretty important aspect of being a co-pilot. These 5 things are something that I think every document, regardless of your jurisdiction, should have in it. So if you do have a power of attorney in place right now, I would encourage you to take that document out, take a look at it, and see if these 5 things are in there. The first one is a power to create a trust. Does the power in the power of attorney document specifically authorize your agent to create a trust? And Medicaid planning, for example, in many jurisdictions, the ability to put a trust in place is going to be critical in determining whether or not that person is going to be eligible for Medicaid benefits. Without this power to create a trust, in my jurisdiction, then the power of attorney, the co-pilot, is not able to put that trust in place and thereby precludes that person's ability to get Medicaid benefits to help pay for their long-term care. It's a pretty big deal. Now, we can always go to the guardianship court and get a guardian appointed to do that trust, but that's an awful lot of effort, time, and expense to get something as simple as a trust in place, when if we would have had this particular provision in the power of attorney to create a trust, then we could have just merely executed the document and moved on. To give you a quick analogy, we've talked about co-pilots as far as appointing a person to act in your place. I want to give you another thing to kind of grab onto, metaphorically speaking, and that is the image of a key or a spare key. Many of you may have locked yourself out of your car or out of your house at some point in time in your life. If you have a spare key under the rock or under the mat or under your bumper, getting into your car, getting back into your house is no big deal. You just pull that spare key out, slip it into the door, click, and you're in, no problem. Okay, maybe not even had to even have a hiccup in your day. Not having that spare key, however, creates a lot of hassle and a lot of inconvenience and a lot of problems for you. You have to go get AAA, you have to get a locksmith involved, maybe you have to break a window to get into the house. All of these things create a situation that requires much more effort on your part than simply getting the spare key and putting it in the door. The 5 things that I'm talking about right now are 5 things that are oftentimes omitted in the power of attorney document. These 5 things are tantamount, or any one of these things missing in your power of attorney is really tantamount to having a spare key that is not cut correctly. In other words, it's not made right so that when you do have to stick it in the door to unlock the lock, it doesn't actually function. And as I like to say, it's really a bad time to find out that your spare key doesn't work in the moment that you actually need it. So focusing back on these 5 things, power to create a trust, very important that it's in the document. If it's not in your power of attorney, you need to have it redone with that power of attorney included. With that particular power included. Next thing is IRA powers. Many powers of attorney that I review do not specifically address the issue of individual retirement accounts or IRAs. IRAs also, when I talk about this, also includes 401ks, 403b plans. All of these are oftentimes referred to as tax-qualified plans. These are savings plans where you've put money into this particular savings vehicle, but have never paid any income tax on that particular money. You pay income tax when you take it out of that investment vehicle. When you take the money out of your IRA, you will then pay income tax on it. Because of these interesting tax requirements and particular rules regarding these accounts, financial institutions and banks are very reluctant to allow your agent, your co-pilot, to manage those types of accounts unless there's specific powers inside the document that grant them the authority to access, manage, and control these individual retirement accounts and other tax-qualified plans. Very important you have that provision in your document. Next, in many states, your home is treated as kind of a super asset. It's something that it's more than just a regular piece of land. In Florida, for example, this is very, very important that your particular power of attorney say explicitly that your agent, that your co-pilot has the ability to convey, to sell, to manage your homestead, the home that you live in. So that's something that I throw in there that I think is very important, that you specifically carve out direction and authority to act on your home, not just real property, but also your home. So it is a little bit different in some jurisdictions, so it doesn't hurt to have it specifically say that your power of attorney has the ability to convey, manage, and distribute your home or your homestead. Self-dealing provisions, very interesting here. Something that I come into my practice routinely and come up against as a limiting factor and a problem, basically, that hampers my client's ability to solve many problems, especially those surrounding Medicaid eligibility. Normally, a power of attorney of your agent, your co-pilot, cannot self-deal. Basically what that means is they can't do anything with that piece of paper, that power of attorney, that would enrich themselves. Most commonly we see this when trying to convey real property from the individual's ownership into the name of the agent or the co-pilot. Even if that agent or co-pilot is the spouse of the individual, they do not have the authority to move the ownership of the home from husband and wife just to the wife's name unless the power of attorney specifically allows them to self-deal or make gifts to themselves. Absent that provision, a deed that's signed by the wife on behalf of the husband to convey that property to herself would be invalid. So what I want you to do is take a look and see if your power of attorney has that self-dealing or self-gifting clause inside of it. Lastly, my big 5 things when I look at powers of attorney is that you should have a backup to your backup. We talked about the idea of the co-pilot, making sure that there's somebody in the right seat, making sure there's somebody that can fly the airplane in the event that you can't fly the airplane. I believe it's also a very good idea to have somebody standing behind that person so that in the event that they cannot act, that person standing behind them can move up, get into the seat, and continue to fly the airplane. Having a backup to your backup. Many of my older clients, let's say you're 89 years old, for example, and you're married, your wife is 89, naming your wife as your co-pilot might not be a bad idea at the moment, but because of her aging and her propensity and susceptibility to issues that would take her out of the co-pilot seat, we should have somebody named in the power of attorney to fill her shoes, to fill your shoes. So have a backup to your backup. All right, alternatives to a durable power of attorney. Many of my clients will come into my office and say, well, why do I need a power of attorney, Sean? I have my son or my wife on all of my accounts, and she can write a check in the event that I'm not able to. Many of you may have this alternative already in place just for that specific reason. In the event of an incapacitating event, you want to have somebody that has the ability to access your bank account to pay your bills. The unfortunate thing about this is that particular alternative isn't very robust. All it typically will do is allow them to write a check on your bank account. But there are so many aspects of your life, of your personal life and decisions that need to be made on your behalf that particular just giving them the ability to write a check does not go nearly far enough to empower your co-pilot to act on your behalf. So I strongly discourage you from relying upon a joint account or a joint checking account as being your solution to planning for incapacity. Other alternatives to a power of attorney can include a living trust. There's a lot of confusion when it comes to this living trust and power of attorney combination. So let me clarify that and give you a little bit of insight into that particular issue. A living trust is a document that's most commonly used for estate planning purposes in order to move your assets to your heirs after you've died. It's a very efficient way. It avoids the court process. It has a lot of merits to solve that particular problem. It also has some incapacity planning provisions within it as well. The successor trustee that steps into your shoes after you've died can also step into your shoes when you lose your ability to manage that trust. They can step up and be the successor trustee, manage the affairs of the trust, write checks, make investment decisions regarding the assets that are owned by the trust, and act as a type of incapacity plan. The problem, however, here is that the authority contained within that successor trustee, in other words, the ability for that successor trustee to act is only, I should say, is limited to the assets that are owned by the trust. In many circumstances, there are issues that are outside the trust, there are assets that are not owned by the trust that the successor trustee has no authority over. Why not? Because there may be assets that are owned in the name of the individual alone. So to give you a quick little insight into what I mean, a quick little example, let's say we have 2 bank accounts down at our local bank. We're talking about a client. In one of those bank accounts, the client's name is the only name on the bank account. On the other bank account, it's his name as the trustee of his revocable living trust. The individual, the client, say call him Mr. Smith here, has an incapacitating event and is no longer able to manage his affairs. If the power of attorney shows up at the bank and tries to access the money that's inside the trust, the bank will tell him no, because he doesn't have the right piece of paper. He needs to be the successor trustee in order to manage the assets that are held within the trust. Similarly, if the successor trustee shows up at the bank and wants to access the bank account that's owned in Mr. Smith's name alone, just in his individual name, the bank will likewise tell the successor trustee, no, we're not going to let you manage that bank account because you're not the power of attorney. So we can, if you can see, an interesting situation develop that in many circumstances, not only do you need a trust if you're a successor trustee, but you may also need to have a power of attorney. Just to reinforce this issue one more time, and again to give you some sort of a metaphor or analogy to wrap your mind around, the way I describe it to my clients is it's like wearing the right hat. You have to have the right power of attorney hat or the right successor trustee hat when you walk into the bank, depending upon what kind of asset you're going to be trying to manage. If it's owned by the trust, you need to have the successor trustee hat on. If it's owned by the individual's name, you need to switch hats and put the power of attorney hat on. I hope that helps in understanding the differences between some of the alternatives to the durable power of attorney. Before I go on to the next topic, I do want to discuss just briefly this issue of healthcare surrogates and the failure to have a healthcare surrogate in place. In many jurisdictions within the state statutes, there is something known as a health proxy law, which will, by default, nominate somebody to act on your behalf to make healthcare decisions for you. That's all well and good. What most of these healthcare proxy statutes, if not all as far as I know, fail at is telling us where you want to go. They do not provide an individual roadmap as to what you want to have happen in the end-of-life type situations. Now, many of you may remember a woman by the name of Terry Shiloh. Unfortunately, Terry resided in a nursing home about 3 miles from my office. During that whole fiasco, and I'll call it a fiasco, of Terry's end-of-life decisions, where we had to have a court case that dragged on for several years to determine what it was that Terry wanted to have done in a situation where she would be in a persistent vegetative state or in some sort of coma where she was no longer had any real medical probability, realistic probability of coming out of that coma. Quite simply, Terry Shiloh did not have a living will in place. There is no alternative to that absent going to court to try to establish to the judge what that person's wishes were in that kind of life-threatening situation. I don't want you guys to be another Terry Shiloh. So please take action to put a healthcare surrogate and living will in place so that we know what your wishes are and we know somebody that can be appointed to make those particular healthcare decisions on your behalf. There's not really a good alternative to the healthcare surrogate and living will, in my opinion. All right, questions you may have asked yourself already or during our presentation today. Some of these things we've talked about a little bit, but let's say a common question that I have is that I have joint accounts. My daughter and my son or my spouse is on those accounts. Do I need a POA? Why do I need a power of attorney? Quite simply, your life is more complicated than just your checkbook. You have other things that need to be done and other decisions that need to be made that only you can make. If we don't have a power of attorney in place that can make those decisions on your behalf, we end up having to go through the guardianship process to appoint somebody through that court process to act on your behalf. Another common question I get, I'm married, can't my spouse take over if I can't manage my affairs? And the answer simply to that question is no, she cannot, okay, or he cannot in the various circumstances. A lot of times when we're married, our spouse is such an integral component of our life. We do everything together. She's on all of my bank accounts. Her accessing that bank account, writing checks on that, doing things that are kind of in this narrow focus, we just assume that she should be able or he should be able to do anything that I can do. That is a false assumption. Your spouse has no more authority to make decisions for you than anybody else walking down the street. So if you want him or her to act as your agent, to be your co-pilot, you absolutely must have a durable power of attorney appointing that person as your co-pilot. Who will make my healthcare decisions when I'm no longer able to do so? Again, awfully nice if you've told us who that person should be through a healthcare surrogate designation. If not, we may be able to defer to the state statute and look at a health proxy, or we can go and get a guardian appointed to make those kinds of healthcare decisions. The ultimate decision of life and death, however, we can really only know whether or not you've told us through a piece of paper known as that living will. Why do I need a trust and a power of attorney? Well, you don't actually need a trust. A trust is a way of planning for your estate. If you have a trust right now, though, it's my opinion and my advice that you do also have a power of attorney in place. Just because there may be assets that are not owned by the trust, we need to have that person with the power of attorney hat that can step in and access and manage those assets that are not held by the trust. I oftentimes refer to this as a belt and suspenders approach to incapacity planning. We may need to have a different hat or a different mechanism to access that particular asset that is either owned by the trust or owned by the individual. Depending on circumstances, you may need to have both of those things in place. Don't I lose control of my assets after I sign a power of attorney? A very common fear and a very common myth that once you sign off on this power of attorney, you lose control over your assets. You are giving up that ability and giving it to somebody else. That is not the case. When you sign a power of attorney document, what you're actually doing is not giving up anything. You are just replicating or cloning yourself or duplicating yourself in someone so that they can act as you in the event that you cannot act on your behalf. Remember, footnote, most power of attorneys, though, actually make that person able to act at the moment you sign the document. That's why we were discussing earlier that you may want to hold that a little closer to the vest if you have any concerns on that person going out and acting without your consent. Lastly, if I have a diagnosis, whether it be HD or Alzheimer's, is it too late to sign the power of attorney? I hope I've made clear that it isn't too late to sign that as long as you still have the legal capacity to enter into that agreement, into that grant of authority, as long as you know who you are, where you are, and who you would like to be able to sign on your behalf. And you have the ability to demonstrate that to the attorney or to the legal professional that's drafting that document on your behalf. Okay, I have a power of attorney in place already. How do I know if it needs to be updated or amended? So as we're reaching towards the end of this presentation, this is oftentimes a big concern of many of my clients and many of the people that I speak to in the community, is I already have a power of attorney, Sean. Do I need a new one or do I need to update it now? It's a tough decision, not a tough decision, it's a tough question for me to answer unless I have the ability actually to look at that document, to see whether or not it has the requisite authority contained with it, whether or not it has the provisions that are necessary to fully empower our co-pilot to act on our behalf. So it's difficult for me to answer that question unless I actually see the document. But there are certain circumstances when you should at least revisit the issue and look at whether or not you should review it. Disability, for example. Not only your disability, but the disability of your co-pilot. If your co-pilot has a problem, if they die, if they become incapacitated themselves, an awfully good time for you to reappoint somebody else to act as your co-pilot. If you have some sort of issue, a diagnosis, for example, that kind of indicates that you are heading towards disability yourself, an awful good time to look at your power of attorney to address the issue and to make sure that you have the right co-pilot in place and that they have the appropriate abilities to act on your behalf. Remarriage. If you get remarried or if you get divorced, in these particular circumstances, you may have appointed your spouse to be your power of attorney. Awful good time to take a look at maybe changing that person out for somebody else other than the person that you just got unmarried to. Kind of obvious, but something that I wanted to just bring up as a point for your consideration. Law changes. This is a tricky one. Not many of you are really out there with your ear to the ground following the evolution of the power of attorney statute in your particular state. But oftentimes your state legislature may change the rules regarding the power of attorney. Recently in the state of Florida, on October 1st, 2011, our Florida legislature rewrote the power of attorney statute. And when they did that, they've incorporated new affirmative things that must happen in order for that power of attorney to be effective. One of the big things that they've required is the initialing of certain particular powers. The failure to initial that power under the new statute means that that power, that authority is actually not granted to your co-pilot, to your power of attorney, to your agent. very big deal that we're running into with people going out and trying to do their own documents. These documents don't clearly indicate that they need to initial those 7 particular powers. Now, in your state, you may have a particularity, or you may have an evolution of your own law that you may not be aware of. Again, another important reason why you may want to look towards a legal professional to help with drafting this very important document. Lastly, moving to another state. Each state has its own jurisdiction and its own laws regarding the implementation of a power of attorney. You may want to localize your particular document to the state that you're moving to. Localizing your document means making sure that that document complies to that particular state's rules and requirements. Quick little example of this is I had recently a client move down from the state of Michigan to the state of Florida. Prior to moving to Florida, about 3 months actually prior to moving to Florida, my client had executed all new documents in the state of Michigan. Her question to me was, do I need a new power of attorney in the state of Florida? My answer to her was unequivocally, absolutely, yes. You need to redo your document. The issues that you're going to run into in Michigan versus the issues that you're going to run into Florida are very different. One of those issues in Florida has to do with Medicaid qualification, and that we may need to have a trust in place to solve this issue of being over income. Whereas in Michigan, they don't have that requirement to be eligible for Medicaid benefits, so their particular document, having the ability to create a trust, is not as critical and vital as it is in Florida, and their documents typically do not address that particular issue. So her moving to Florida, her moving to this jurisdiction, she moved into a whole new set of laws that her document needed to be able to address. So moving to another state is a very important issue regarding changing or amending your power of attorney document. Okay, as we reach the end of today's presentation, I wanted to provide you some additional resources which you can go out and continue your education on this particular subject. HDSA provides a lot of good resources at their Caregiver Corner. Their website address is here on the screen. By clicking on that, you have the ability to go right to the Caregiver Corner and access a lot of quality and very, very good, easily accessible resources on this and other issues that you'll need to be aware of. HDSA also does their Lunch and Learn webinars. You can do that by clicking and access those by clicking on the website on your screen. And lastly, they have some publications available which can, again, aid in your continuing education in this particular area and other areas important to planning for the future. Lastly, I have some resources available. I have a on the web. There is a power of attorney video that you can access on YouTube. You can access that by clicking on the link on your screen. And we've also made available to you a book that I've written on planning for long-term care, which deals with accessing Medicaid to pay for the cost of long-term care stay in a nursing home, as well as issues regarding incapacity planning. So I encourage you to click and download that PDF and go through that book. I find it very helpful for expanding your knowledge regarding incapacity planning and planning for long-term care issues. So it's this point in time that I'd like to thank HDSA and thank everybody for listening to me speak to you today. And if Jane has any questions that we'd like to go over, I'd be happy to take those at this point in time.
Thank you so much, Sean. There are a few questions that I have coming in, and I'm going to ask you them and hope that you can give us some feedback. So
Sure. The
first question is about statutes in other states. This individual is actually currently a Floridian, but has a daughter who lives in another state.
Okay.
So she would like to have plans that work for both states. And how does one make that happen?
Well, yeah, living in Florida, we have a lot of people we refer to as snowbirds that come down from that live part of the year in one state and then live in Florida for part of the other state. In those particular circumstances, it's usually my recommendation that you consider having powers of attorney localized for each jurisdiction that you're residing in. So, for example, if you're living in New York State part of the year and then you come down to Florida for the winter, you should have a New York power of attorney in place, and you should have a Florida power of attorney in place. In the particular facts that you gave me, however, if Mom's, for example, is living here in the state of Florida and is not making trips back and forth to another state, doesn't own real property in another state, doesn't have real significant contacts with another state, just simply because her daughter lives in another state, it's not necessary to have two powers of attorney under that circumstances. Her daughter living in, for example, in New York doesn't change the fact that she can't have a Florida power of attorney for her mom. So does that answer your question?
That makes a lot of sense, yes. So, but the other question that came up for, so basically, but is there somewhere that people can go online or anywhere to get information about the laws in their specific state?
Good question. I answer that question not so much flippantly, but I will say this from a professional standpoint. There's kind of a reason why I went to law school for 3 years and then have been practicing for the last 23, is that it gives me unique insight into what the laws are and how they affect my clients. The ability to go out and research these kinds of laws on your own, while possible, it's unlikely that you're going to get the full picture that you need in order to adequately assess your situation. So while there are resources online where there are, the American Bar Association has a good publication, for example, your local state may have, a local state bar association may have some materials available for you. All of these documents are generic by their nature and may not adequately address your particular facts. So my answer to that question would be there's probably no one good online resource to go to that would definitively educate you and answer your particular situations. I would encourage you to really seek out a legal professional, a lawyer, to advise you on the things that are required to plan for your particular incapacity events.
That makes a lot of sense. The attorneys are the experts in the law. However, just to turn it around again for
sure. Yep.
some of
I'm not trying to feather my own bed here. I try to be helpful. I mean, that's why doctors exist. You can go all day long and look at as many websites you want regarding HD, for example, and get all kinds of manners of insight into that disease process. But ultimately, it's a one-on-one relationship that you have with your physician that's really going to be able to answer your questions and really personalize it to your own particular circumstances. So
absolutely. But however, oftentimes, it does come down to dollars and cents. The finances are a problem, and a family can't afford an attorney.
Correct.
Are there any, first of all, or twofold, are there any resources available to folks like that, specifically based on financial need? And the second part is, wouldn't it be better to have a DIY, do-it-yourself document rather than having nothing at all?
Okay, great questions, actually. So to answer your first question regarding resources that are available for people who have limited financial means, just to give you an idea of cost in this particular situation, in my practice, I charge $150 to do a power of attorney. So that's the extent that it costs to get this particular incapacity plan in place. But if that is not financially a viable option for the particular individual, there are legal aid societies and within your community oftentimes that can produce this document for you. And there are also attorneys that are willing to do these documents on a pro bono nature. In my particular practice, I routinely create powers of attorney and healthcare surrogates for clients who do not have the financial means in order to draft and to pay for these documents. So pro bono or a legal aid society on that particular issue. To answer your second question regarding DIY or do-it-yourself documents, is it better to have that than nothing? I would say yes, it's better to have that than nothing. But be careful. These DIY documents oftentimes can create a situation of what I call false reliance. It brings us all the way back to that point in our discussion today when I was talking about the spare key. If you have a spare key out there and you think that you cut it yourself, you made it yourself, and you're hoping that it's going to work when it comes time to unlock the lock. And you think, well, I got it. I got a spare key. I don't need to go out and get a professional to create one for me. The problem comes is when you may have that false reliance, when the actual situation occurs, when you need to use the document, it may come up short. So DIY, do it yourself, better than nothing, absolutely. But it's such an important aspect of your particular personal life that I don't think it warrants you relying upon a do-it-yourself type of mechanism. This is just too critical of an issue, especially when in the context of HD, where we are moving towards an incapacitated individual at some point in time. just by the nature of the disease process. Not something that I would encourage you to explore on a DIY basis, but grudgingly better than nothing.
Makes sense. So switching gears, this question comes from a caregiver. This person's husband has HD and has already taken a lot of steps, already has all of these papers in place except for the DNR.
Okay.
However, are you recommending, or are you saying that their healthy 23-year-old son think about having the living will and the designated power of attorney as well? The durable power of attorney as well?
Can you let me clarify your question. If the question is should her healthy 23-year-old, her husband has HD and her son's healthy, correct?
Yes.
Should her healthy 23-year-old have a power of attorney and a healthcare surrogate? Mm-hmm. My answer to that question is yes. Pretty much unequivocal. I always use my 19-year-old daughter as an example. She's 19 now. She'll be 20 here in a little bit, but she's 19. I drafted a power of attorney and a healthcare surrogate for her because she drives her motorcycle to campus every day. If something should happen to her, and she has bank accounts, she has her own investments at this stage in her life, she has health decisions that need to be made on her behalf. And she may be in a situation where it may be in a life or death type of situation that we need to have somebody available with the legal authority to act on her behalf. So regardless of your age, you are just by your existence susceptible to running into an incapacitating event. Whether you're 23 or 83, whether you have a diagnosis or no diagnosis, you should have a power of attorney and healthcare surrogate in place.
Makes a lot of sense. Preparing is always best. So,
we don't think when we're 23 we're going to live forever, and nothing's, we're invincible. There's nothing going to touch us. Well, that's not reality, actually. So you should have it in place as well.
So we are a little bit over, which is great. I'm so thankful to you for all of the really important information. Are there any other questions from folks? If you have any, now is your last chance to get these questions answered live. However, if you would go to the next slide and show your contact information, you have generously given individuals the opportunity to ask any sort of questions later on. So,
absolutely. And on this slide, what we have is my contact information with my email address in purple. If you click on my logo, you can go to my webpage. If you want to follow us on Facebook, just click us on Facebook. And if you want to see some of the other videos that I've produced on other issues such as Medicaid planning and estate planning, you can go to our YouTube channel and watch those as well. So a lot of good resources here on this slide.
That's great. Thank you so much. And just as a reminder to folks, we are going to be posting these slides, so don't worry and try to hurriedly write down this information. It's going to all be on our website. So I'm not seeing any other questions, so thank you so much.
Thank you, Jane, very much.
Folks on the presentation, please don't forget to fill out the evaluation so that we can know what else we can offer in the future.
Super. Thank you, Jane, very much. Appreciate it.
Thank you so much. Have a good day, everyone.
Okay, goodbye, everyone.